All right, so now we have, I think, a great in-house panel. And so what I'm going to do is turn it over to our moderator, Steve Otten, in a minute. His full bio is in your packet, and Steve and I practiced together about 10 years ago. It's been a long time now. So let me just give you a highlight of what Steve is doing now. Steve is vice chair of the ANDA and Biologics group at Cozen O'Connor, and he's only been there for less than a year. Before that, he was vice president and head of intellectual property for North America for Sandoz, the second largest generic company in the generic pharmaceutical company in the world. He also runs the LinkedIn blog on Hatch-Waxman and biosimilars that has over 4,000 members. And before he went in-house, he was in private practice for a while, and he was both lead trial counsel, lead appellate counsel. He has a bachelor's degree in chemistry from the University of Illinois and a law degree from Chicago-Kent. So let me turn it over to Steve.
Thanks, David. Thanks to my co-panelists here. Happy to present with them. I heard Bob's opening comments here and talking about civility, right? And Dave was talking about how I started my career. And let me just tell you that those of here in IP, you have no idea how lucky you are, because I started my practice in state court as a plaintiff's lawyer, right? So it's a much different practice than IP. So just count your blessings here that you practice in IP, because it's a very civilized practice overall. Let me begin with some brief introductions of my panelists here. And we'll go down the row here if I can get them in order, starting with Jim. Jim Trussell here is the Associate GC and Chief IP Counsel at BP. He heads up their global IP practice group and is responsible for all patent, trademark, copyright, trade secret, and related technology law matters. And prior to that, he was with 3M, most recently based in Shanghai for 2 years, where he managed the IP operations in the Asia-Pacific region. To his left is Karen Nelson. She's an attorney with AbbVie, as you know, is part of the Abbott organization, and she's been working in IP litigation with them since 2007, primarily on ANDA cases. The ANDA means abbreviated new drug application. That's a generic drug application. Working on ANDA cases, biologic cases, and other patent litigation matters, both in the U.S. and internationally. Prior to that, she was a partner at Kirkland & Ellis. Next up is John Wood, and he works at Bridgestone Americas in Akron, Ohio, and is the Chief IP Counsel for that organization. It's a subsidiary of the Bridgestone Corporation, the largest tire and rubber manufacturer in the world, and owner of the Bridgestone and Firestone brands, of which you've undoubtedly heard of. Prior to that, he was Senior Counsel at Eastman Chemical Company in Kingsport, Tennessee, and before that, an associate in the law firm of Workman Nidegger in Salt Lake City, Utah. So he's obviously been a few different geographical places here. Here in a JD from the University of Arkansas, a master's in organic chemistry from the University of Alabama, and a BS from Harding University, also in Arkansas. Last is Paul Rodriguez, and he served as VP and Chief IP Counsel at R.R. Donnelley since 2007. He is responsible for all the IP matters, including strategic portfolio management, product and process clearance, litigation, enforcement, development agreements, and due diligence. Prior to that, he was the AGC at Pactiv Corporation for a number of years, and then he began his career, or actually immediately prior to that, was a partner at McAndrews, Held, and Malloy as well. So that is the brief introduction of our panel. I'll give you a little bit of a roadmap of what we're going to go through today, and that is really just engage the panel and engage the audience on several different IP topics. And if at any point you want to ask a question, feel free to interrupt, although we'll have reserved time at the end as well. But we like to keep it an energetic and engaging session as we discuss some of these questions for industry or discussion with industry as the panel was presented in the materials here. So with that, I'm going to start with a very open-ended question, and probably one with the broadest implications that we'll encounter today, and that is, for the panel to think about this, and what's the biggest problem that we have in patent law today? And you're not going to get off the hook by just identifying the problem. Do you have an idea of how to fix it? So pause and think on that for a second here before I call on some of the panel members here. Because I think it's going to a lot to be dependent on the industry that you're in. But let's begin with Paul. Paul, if you've got an answer for us on what you perceive to be the biggest problem in fixing patent law today.
I'm not sure if I have the answer, but I certainly have an idea of what I think is one of the most significant problems that we face, which is in the patent litigation context, it's really the high transaction cost of identifying and disposing of, I guess, what I would characterize as frivolous lawsuits. And certainly there's been a lot of attention directed to that, both with commentators and I think some of the intentions of the AIA. I'm not sure, though, that we've really identified the right solution. I'm not sure if it's going to be a single fix, and if there is one unitary solution.
The high transaction costs of just from the IP system overall, or do you mean specifically as to litigation, or from the due diligence aspect as well?
That's part of it, but I think the bigger problem for me from the in-house perspective is defending patent infringement claims where you do your quick evaluation of the claims, you know that it's a very thin case, but there's no efficient, cost-effective way to dismiss the case.
Right.
So you're faced with the choice of not only your outside costs of legal counsel, experts, but also the internal resources you're going to have to devote, the opportunity costs. It's just very expensive to dismiss and dispose of that case. And so from a policy perspective, that really puts corporate defendants often in a bind as to how to handle that situation.
And what's a typical party, what's a typical litigation like for R.R. Donnelley? I'm not intimately familiar. I'm sure others aren't as well. I don't know if you're facing other competitors in your industry, if you're facing cases against NPEs and the like, or maybe a mix of both?
I would say it's some mix of both. We're fortunate in that we're not, our industry doesn't have as much patent litigation activity as some others. And our historic space isn't as active or fertile ground for non-practicing entities. But I think increasingly, as everything becomes more digital and we're moving to more web-based delivery of services, we are seeing an increased trend in patent infringement assertions among our different business units.
Right. Karen, you're in the pharmaceutical world.
Yeah.
Is your view the same or different that Paul might have?
We do have, probably to a little bit lesser extent, we have the non-practicing entity problem. We definitely still have it, and I seem to get a lot of those cases. But I don't think it's quite as a big concern in the pharmaceutical industry. I think our concern as obviously AbbVie is a branded pharmaceutical company, so we have a lot of investment in research and development and costs, and as well as clinical development costs that we have to build into the price of our products. And as particularly with the first to file system, we have a tendency to come up with a new idea, and you have to get the patent fast. You have to work diligently to get a broad concept patented quickly. So for us, written description has become more of an issue. The law on written description is changing, is becoming much more severe. That makes it a lot more difficult for a research and development type company to, you need to file quickly, but as soon as you get this concept and idea, you go and file a patent. And a lot of times there isn't as much, clinical development data. So, for example, you may say, I have an animal model that shows that this works that this works for this particular, to solve this particular problem in a mouse. But yet you're going to file claims that would cover how it works in a human, because there's plenty of examples historically that that's how research and development is done. You first do it in a petri dish, then you do it in a mouse, and then you have to test it in a human. And a lot of times the patent is filed before you get to the human stage, because at that point there's a lot of people out there who know about your invention, and you need to file your patent. And so the written description law has become very severe and very difficult for research and development companies like AbbVie to sustain their patents at a later point in time.
Well, the written description, I agree with you, is going to become increasingly important in the pharmaceutical world, particularly as the marketplace is shifting from small molecules to biologic products. And for those that aren't familiar with that terminology, small molecules are what your drugs traditionally have been, like Lipitor, aspirin, things like that are made up of definitive atoms that you can characterize what their chemical structure is. As the market's moving to protein products, biologic products, they're much more complex. if we can make a simple analogy of saying a small molecule is like a bicycle, you could clearly define that and you know what it is. A biologic would be more like a 747. And it would be hard to structurally claim that, and you're left with this problem, as Karen pointed out, from a written description perspective. How do you describe that in the application? And that also dovetails with the enablement requirement. So your point's well taken, because I believe it's in the last 12 months or so, since Lipitor's is fallen off and gone generic, I think the world's best-selling drug is not going to be Humira,
yes.
which is a protein product, right? And so you're going to see this shift in the landscape, and going back to the Federal Circuit and see these cases where they're going to really struggle with these issues of written description and enablement. So as you were answering that question, is that what you see as being the biggest problem in patent law for at least your industry?
For our industry, it is. And going to your point about the biologics, obviously AbbVie, the biggest product is Humira, which is a biologic. There is the new Biologics Act, which allows generic biologic, essentially what the equivalent of what we would call a generic biologic, a path to market. And those biologics are going to be coming to market, are going to be, seeking approval and getting to the stage where they may be marketable in the next, year, 2 years, 3 years, 4 years. You're going to see a lot of these so-called biosimilars. And the question is, because they are such complex, incredibly, even if you have the same biologic sequence, that's not enough to make it a biosimilar. It has to have the same, connections within the DNA type sequence that is going to be, it's a real question of whether these biosimilars can really be able to do that, and are, because they are such big complex molecules, are they going to hit something else in your body that you're not, that's going to be, a different receptor somewhere in your liver that Humira didn't touch, because it has a slightly different shape. The shape might be just a tiny bit different, and so there's now this path to allow these biosimilars on the market, and then but there's also a lot of questions with the law. There's a lot of ambiguity surrounding the new law that's coming into that's in effect, and about how and what steps these biosimilars need to take as far as the legal steps and meeting the requirements of the statute. Do they even have to meet the requirements of the statute? I mean, there's a lot of really big questions surrounding the new law that I think are a big opportunity for people to talk about, and
right.
There's a lot of questions.
Okay. Thank you. And we'll open up the question also to Jim and John for your respective industries on what you perceive to be the biggest problem that we have in patent law today.
Since I have
looks like Jim's got an answer first.
Since I have a microphone around my neck, can I ask Karen a question?
Of course.
Is your problem written description or the breadth of the coverage that you're going to?
Well, it's really both, because obviously you have to describe the claims across the entire breadth and be able to enable the claims full breadth. And so the question is, what does that take? What does that mean? Is it enough to show,
right.
sort of
so
like,
the breadth
sort
of
of
the
like
claims.
I discovered the Rocky Mountains. I discovered that there is a mountain over there that's high, and it's really, it's amazing. And someone else comes along and says, well, I have one that's, in Canada, and I have one that's,
right.
Colorado.
So when you go to management, you have to say, so you're concerned that someone else may be able to sell a competing product that you may not have been able to claim because of the breadth of your written description.
Or that I did claim, but they're saying
their claim, but the written description didn't cover it. Okay.
But they're saying that I don't have enough description in my disclosure to cover what they did as well.
Sure. And I'm sure that along those lines, and I'm sorry to get off topic there, but it's along those lines, I think that in both Jim and my industries that you'll see a lot with the biologics coming along too, with sustainable materials and the focus on environmental friendly materials. But just quickly, and I don't want to reiterate what Paul said, was that I think litigation I see as the problem, but I want to hit it from another angle. Is not only do we have maybe some nuisance litigation that Paul spoke of, but going into management and talking about the cost, the time, the efficiency of resolving business issues, as Judge Lynn said, with some certainty on our own products that may be being infringed in their own patents, because I've been in meetings before where it's just not financially, it's not a good business. It's too expensive to file litigation. The product and the amount of money the product is bringing in doesn't justify the cost of litigation these days. So it's
because
not
it'd be
adequate.
different than pharma because you don't have a lot of your revenues for your significant portion of your P&L tied to one particular product. Is that it? Because the value of the product doesn't justify the expense of litigation. That's what you're saying, right?
That's what I'm saying. I think I would be curious. I think Jim would probably say the same thing. I don't know. Are we in similar industries?
Yeah, we are. And in addition to the cost, I think, building on that theme, one of the problems is with non-practicing entities in particular, this terrible mismatch in risks. So if we were looking at a competitor, for example, if we were looking at a competitor and they were to bring a suit against us, we'd be looking at countersuits, we'd be looking at discovery, their inventors, and if you're a plaintiff who's practicing in an industry, you recognize this is not a risk-free event to go bring this suit, and I think that tends to keep cases meritorious, the risk level somewhat balanced, and people come in and are seeking appropriate enforcement. A huge problem with NPE is there's virtually no risk to the plaintiff in many of these cases. One example we could bring, you'll recall before the AIA fixed the patent mismarking NPE scourge, I would call it. Really right at the peak, we had one of these cases, BP Lubricants, and it's a typical NPE. There's virtually no way to bring a counterclaim. There's no way to create any discovery costs for them. The other difficulty with this in a balance of risk, it's really hard to get a case called exceptional and to try to seek fees. I think if that were easier to obtain, and you had a more proportionate risk balance, you'd see a lot of these less meritorious cases go away. What we need to do in cases like this is occasionally pour in many more resources than the risk warrants, and that was a case, the BP Lubricants case. In fact, we took a writ of mandamus to the Federal Circuit, asking them to, really extraordinary relief to override the district court's judge's discretion. And we had the pleading requirements kicked up as you'd expect in a fraud case. The patent mismarking, although it's gone away largely, required an intent to mismark. And you recall all of those claims said, defendant has a patent department, defendant is competent, there's no way they could have done this without intent. In essence, they ask you to plead back, well, we're really not as smart and as good as you think, it really was a mistake. And they would argue back, no, you're too good to be incapable of mistakes, this must be intent, and it's enough to make the claim stick. Well, with the writ of mandamus, we were able to raise the bar on that pleading requirement. I'd say if that hadn't been later fixed by statute more permanently, maybe with a higher pleading requirement, you could get more district judges to say there's no meat behind this complaint. You can't just say, as you see in a lot of these cases, if you run an internet system, you infringe. If you use email, you infringe. If you mark, it must have been intentional. We really have to up the pleading requirements, giving us an opportunity to seek sanctions, I think, and take other measures we can talk about later if we get into this. But this disproportionate risk really distorts the system.
So what I find interesting about your comments from the panel is we take a small cross-section here of what's going on in industry. And depending on your industry, you're going to get very different answers to these questions, as you see as the biggest problem. You see a couple of answers we've had have been the NPE problem, the non-practicing entity problem, the cost of litigation. The cost of litigation isn't matching up to your P&L in terms of the investment you've got to make in order to keep your product on the market or clear your freedom to operate. That's quite different in the pharmaceutical world, as we heard from Karen. Her answer wasn't related to the cost of litigation and NPE, because in that scenario, in that market, really, litigation is a cost of doing business. It's built into the statute, right? For generic drugs in the Hatch-Waxman statutory scheme, that's a natural process of litigation. And you're not going to have a lot of NPEs in that space. And when I spent 7 years managing Sandoz, the world's second largest generic drug company, its IP department, we had well over 100 patent litigations ongoing at any time in North America alone. Not a single one of them was directed to an NPE. Right? They're all between major pharmaceutical companies at any time. And so our cost of litigation was built into the model. So I find it revealing and fascinating at the same time that Karen, you're talking about the problem being written description.
I don't want to take away. We do get non-practicing entities who do come after us, and I've had, in the 5 years I've been at AbbVie, Abbott, I've had 3 in all of those cases. Because I think we're in an industry where we're less targeted by the NPEs, that we have a policy of fighting them and just expending the resources in those cases. Because we don't want to become a target,
right?
a repeating
AbbVie's got
target.
deep pockets. You're going to be a target, right?
Yeah.
It's going to happen.
Yeah, and the non-practicing entities that we deal with are primarily, entities who may have developed, a molecule or a sequence of some sort, and they're saying, you use that in developing a drug. And I had a case last year where that was the case, and they were then seeking, it was something that was done in the early development. We used a research tool of theirs, and they were claiming that because we used that research tool, that we were then liable. The entire drug, the later developed drug that would have been non-infringing, was subject to a royalty.
But the NPE wasn't from a holding company that was formed in Marshall, Texas, the week before suit was filed.
No, but they were pretty close.
Right, so
I think they were formed in
different industries, and I think
Illinois.
that ties back. Judge Posner is supposed to be on the program this afternoon. He's got that article that was in the Atlantic last year of why there are too many patents in America, and the one industry he singled out that says it's okay for them is the pharmaceutical industry, right? Because it's just different model. So I'm seeing that problem, not the problem, but I'm seeing that observation play true with the comments today, just based on the slice of industry we've got represented on the panel here. One thing I do want to ask about from the NPE perspective, and what's the fix, and that is, have you considered the routes that have now been in place because of the AIA? Have you looked at post-grant review and inter partes review as possible mechanisms to challenge these patents without the relatively higher cost of litigation? Anybody got an answer on that one?
Yeah, I would say that, obviously a lot's to be determined as to exactly how those procedures are going to work and how effective they're going to be, but I think we're looking at them certainly with interest, and I think those could be possible mechanisms and perhaps part of the solution. I do just want to make one quick comment that I know NPEs are very popular targets, but certainly in my experience, operating companies are just as capable of exploiting the high transaction costs of the system, and if you look at a lot of the counterclaims in lawsuits between operating companies, I think you'll sometimes find some pretty thin counterclaims as a way of getting leverage. So, I think increasing costs on the other party, increasing their risk. So, I prefer to maybe focus on, legitimate meritorious claims versus more frivolous claims.
Right. Well, let me turn the question around to the different one, and that is, because of the different effect on different industries, should there be different standards, different patent standards, industry-specific? Should there be industry-specific patent standards? I guess a better way to ask the question.
I've got a view on that. I think we need a principled system that applies uniformly, and I think it gets very dangerous to start singling out industries, technologies, parties. So I agree completely with Paul. The NPE scenario is a great context to talk about many of these fixes, but the fixes have to be principled and they apply to any party. So you look at the SHIELD Act and some other things. I think it's very dangerous, for example, to try to single out a type of party and put different requirements or different sanctions there. A meritorious claim is meritorious. A lacking claim is lacking, and we shouldn't single out individuals. You hear things about computer-implemented inventions. Should there be a different scrutiny? No, we have 101, we have 102, we have 103. Certainly those are tested differently depending on the technology, but I think you need to stick with those principles. You start singling things out, and I think it gets very dangerous, and it can turn into a flavor of the month, and what industries are favored, what industries are disfavored, and I think it could just get us in a very complicated patchwork that doesn't necessarily help any industry if you start worrying about how to do this case by case.
Right.
And I totally agree with that. And even in this article, or Posner does favor the pharmaceutical industry, saying that we are worthy of long-term patents. I completely agree that there should not be a sort of a 2-tiered system or a 5-tiered system, because there is a real risk that industries become unfavored. We are experiencing that currently in Brazil, where there are there's been statutorily developed law that says that it's harder to get a pharmaceutical patent in Brazil right now, because they have included a public interest component. I mean, obviously, nobody likes to pay a lot of money for anything. Pharmaceuticals are very expensive to develop and get clinical approvals, because not only do you have to, have your scientists working. Once your scientists come up with a great idea, that's not the end of the story for a pharmaceutical industry. You have to then spend hundreds of millions of dollars proving to the FDA and its, and its similar agencies around the world that the drug is safe and effective. And that can be extraordinarily expensive. And, we're now facing, laws in some other countries, including India and Brazil, where they have enacted different standards in the pharmaceutical industry because, they're including a public interest component. And I think when you have that type of 2-tiered, 5-tiered system, you run into those problems where people decide something is not worthy of being protected.
The corollary on that public interest component as it relates to IP, I mean, it's a very significant issue across the globe, particularly in India with respect to compulsory licensing, right? Have you encountered that issue in your practice at all?
We do have some compulsory licensing, particularly we do have some patents. We have some HIV drugs, and particularly in the developing world, where people there don't have resources to pay for what is essentially a life-saving drug. There's a lot of momentum in policymakers in those countries to say we don't want to have patents that cover these drugs. We don't want to. And what they're essentially saying is we don't want to pay for the development of those drugs. We just want to have them. And what that is doing is it's forcing countries that do have strong patent laws, like the United States, Europe, to essentially then be funding all of the research and development for the entire world. And maybe that's acceptable. Maybe that's fine. Maybe that's what we want to do. But we should think about that before we just start.
Those policy questions are always difficult to answer. But let me go back and invite Paul and John to answer that question about whether they got a conflicting or different viewpoint on should we have industry-specific patent standards.
No. I'm not in favor of it either.
I'm not in favor of it either. I agree with the other panelists that we've had these laws in place for a long time, and they've been suitable. And every time it seems that there's a new industry that comes along, they think that it's different. And it's easy for me to say that because I'm not in one of those industries, but I'm fearful that we'll end up like the tax code. I like the simplicity of what we. So
we needed a telecommunications person on this panel. Right?
Yeah. It would cause some argument, maybe. Maybe we get some discussion. Because
I don't know enough about your business, whether you guys have industry standards that get adopted. Right, sometimes. Because that's the whole morass of that industry, because then it becomes these patent pools and who's licensing whom, and then you got situations where Google's buying Motorola Mobile, right, just for its patent arsenal, and then says, okay, well, this is our defensive position. We're not going to sue anybody on this open source code unless they sue us first, right? So and becomes just because they've gone on record as saying that they want industry-specific standards, right? Mark Lemley is also on the program today. I believe he's written an article in that space here. So it's very interesting. Again, one of these questions, you get a different answer depending on who in the industry you're talking to. Let me move to
it's certainly you do get different perspectives, but I think we should be careful about how we manage the patent system.
Right.
And I think be careful of these focused approaches. You should always ask yourself, what if you happen to be on both sides of this? So, we're not the biggest target for computer-implemented NPE suits, but at any given time we're defending one or two. I'm not the biggest developer of computer-implemented inventions, but at any given time we're trying to protect some. Well, I just want a fair system. Right. I don't want to gut it. I don't want to overplay it. And I think if you ask yourself, you're as likely to be a plaintiff or defendant, that would likely tend you back to, well, we just need some core principles as opposed to trying to break out specific industry approaches.
Well, maybe that's all going to come together as the information age and technology keeps growing exponentially. We're going to have these computer systems that are going to be integrated with your businesses. For example, the pharmaceutical industry, right? There are programs in place now to restrict access to opiates and other types of drugs, and they're all tied. They're linked to a computer system. So, are we going to have then these NPEs and these these entities and these holding companies that amass nothing but stacks and stacks of patents now are going to put the pharmaceutical industry in their target site. So
they already have.
So no doubt, right? But only a sliver has happened yet, right? I think we're on the tip of that, and we're going to watch that unfold in the coming years here. But let's move to another topic that Judge Lynn had brought up, and that was the involvement of the U.S. Supreme Court in patent cases. As we've seen in recent years, the Supreme Court has taken on many more patent cases than it has in recent times. And in fact, this spring alone, I think there's 4 or 5, depending on how you count, IP cases before the court, beginning also with the Nike decision that was issued in January, bringing us full circle to, I think there's an argument on Monday. It's very, very important to the pharmaceutical industry, right? And not the pharmaceutical, but the genetics industry with the Myriad case being argued on Monday. And in between, we've got several pharmaceutical cases with respect to defective design and how that's coupled with the failure to warn and the preemption issue. We've got the pay for delay case that was argued just at the end of last month. And then thrown in the middle, we get this sensationalized patent exhaustion case with the single farmer versus Monsanto. Right? I struggle to understand why in the world the Supreme Court took that case. It'll be interesting to see how it plays out. Other than the sensational effect of a single farmer, six-pack Joe Farmer versus Monsanto, what seemed to, at least to me, a pretty clear licensing issue. Right? I didn't see any patent exhaustion issue, but perhaps the court, as Judge Lynn mentioned, from its policy perspective, has something profound to pronounce in its opinion that'll be coming later this year. But let me start with just that background of cases and if they've made your radar screen, do they impact your industry, and what, if anything, are you planning in response to those decisions? Jim, let's start with you.
Most of these are not really right on our industry, although I just would comment generally, I think it's appropriate for the Supreme Court to try to bring general principles of law and apply them in the IP regime. And I think that the IP case law does need to evolve and needs the right test cases, so perhaps sometimes the Supreme Court jumps in early. I think one of the biggest things that frustrates me, and I think it's died down a bit, but this lack of permanent injunction at the end of winning a trial. I do understand bringing common law principles of injunctive relief, but you know what? The patent law says the patent holder shall have the right to prevent others. Well, I don't know how more clearly you can say shall have the right to go get an injunction. So I think the Supreme Court missed the mark on that one. And I think it's a delicate balance on, bring some general fundamentals in, but not by plowing over patent law requirements as you do this.
I think the counterpoint to that would be, there have been a number of cases, and it's certainly been an uptick, would be in cases where the patent's been defeated at the district court level, particularly in pharma cases where a generic sponsor will actually defeat the patent, either the judge will rule it invalid or find it not infringed, but then grant an injunction. And the generic can't launch. Isn't that the right that they had in beating the patent at the first stage of trial? They have the right then to take on that risk and launch the product, but yet the judge, for whatever reason, says, no, we're not going to let you come to market. We're going to let the appellate court figure that out and keep the status quo until then. So,
well, I'm not going to defend that at all. And again, if you want to apply principles of equitable relief, I'm not going to defend how you'd get equitable relief there.
Right.
No, it's just more to the fundamental. If you win a patent case, the statute says shall have the right to prevent others.
Right.
You don't have that right anymore.
And the reverse isn't true either, right? If you lose your patent case,
you shouldn't have the right.
You shouldn't get your injunction, but it happens, right?
No, absolutely.
Right. Karen, we'll move with the same question to you with respect to the Supreme Court issues.
I guess the case I find, well, I guess there's two cases I find interesting. One, because our case was the reverse payment case that was argued last week or a couple weeks ago. It is interesting. I also find the Myriad case to be very interesting. Not sure. I think the Myriad case I find to be, from a policy standpoint, very interesting because the idea. And the way this is framed in the general public is, can you patent human genes? And I don't really think that's what the patent claims. So I think that's sort of a shortcut way of what actually Myriad invented. But the question is, can you take a part of a naturally occurring, substance item and isolate it. And then claim that as a patentable claim, and I think that's a really interesting concept. because what they did is they did take something that was naturally occurring, but by the virtue of isolating that gene sequence, they did come up with something. That it was a novel and inventive thing. We'll see if the Supreme Court agrees with me. But I do think that it is an interesting policy issue of whether we really want to allow that to occur in the first place. Obviously if we decide that we don't want to have those as patentable inventions, then I think we decrease the motivation for industry to identify and isolate those issues. And in this particular case, it's a breast cancer gene. Do we really want to limit people or not provide incentives for people to discover these gene sequences? And there's certainly a lot about the human genome we don't know, and do we want to disincentivize industry from pursuing those?
Let me ask you a question about the Andrew case. What happens if it's a tie?
What do you mean by a tie?
Well, because there's recusal, right? So only 8 judges are going to participate in the opinion, right? Yeah. What happens if it's a tie?
Well, if it's a tie, I guess we win.
It'd be a de facto affirmance, right? Right. So let's start with that premise, a de facto affirmance, right? So was it by chance or was it by intent that they took that case and not the Cater case?
I don't know. I think, I think there is a possibility here for a tie. I don't. It does seem kind of unusual, though, that you would take a case where you didn't really want to make a decision in the first place. Exact
same issue, right? They haven't granted cert in that case. That petition's still pending out there unanswered, right? So I'm just observing. I don't know how it's going to play out, but it's an interesting scenario. What would happen if they had taken that case, the Cater case, rather than the Androgel case, and it ends up in a 4-4 tie? Interesting scenario. Yeah. So let's move on down the panel then.
I don't know if the whole group knows what the case is even about, though. So do you want to explain?
I can spend 30 seconds on it, right? So what the issue at play, thank you for pointing that out, Ken. The issue at play is the reverse payment, the so-called reverse payment in pharmaceutical cases. In a typical patent case, right, what happens is the patentee sues the accused infringer. They litigate it out, battle out several years in court, right? At the end of the day, if they have a settlement agreement, there's a royalty agreement that flows consideration or payment from the accused infringer or now the licensee back to the patent owner, right? In the pharmaceutical context, what happens is that they take a look at the market scenarios, and what the patent holder will do was give a payment or some other consideration to pay to the accused infringer or the generic sponsor to stay off the market for a period of time, right? And at the end of the day, they do come in before patent expiration. So you have the so-called reverse payment because the consideration is flowing from the patentee back to the accused infringer. And there's a lot of commentary, a lot of thought process, a lot of thoughts out there. That's fundamentally unfair. It actually robs consumers of the benefit of an earlier entry. We could debate all day on this because I think that's based on the premise that the accused infringer is going to win that case and come in before patent expiration nonetheless. But those have an added twist of the exclusionary right, as Jim talked about, right, and how that brings with it some antitrust concerns when you couple it with this payment back to the accused infringer. So that's sort of the battleground on the reverse payment, pay for delay, and there's a split among the circuits that came out that way. In the Andrew case, the circuit affirmed and said, okay, that was within the scope of the patent, and it didn't run afoul of the antitrust laws, right? And then we get the differing circuit, I think it was the Third Circuit, in the Cater case, that actually was the second time around for this particular product because the FTC had lost in the 11th Circuit on that case. But now we have a private payer or private antitrust suit in a different circuit to create that split who used a different standard, didn't use the scope of the patent test, used a quick look rule of reason under the antitrust rubric and said that when there's that payment flowing back from the patentee to the accused infringer, that's prima facie evidence of a unreasonable restraint of trade, right? So implicating it was going to be an antitrust violation. So that was the two different split in the circuits. And that's why it's very interesting with the recusal at the Supreme Court that the court took the one case where it affirmed, right, or said permissible within the scope of the patent, not an antitrust violation, versus what might have happened had they taken the other case where it came out completely the opposite way, right? So that's sort of the background. So I think with that, did I cover it adequately? Yeah. Got it? Okay. So that's sort of the fun issue, and we'll see that play out with the decision later this year, because it's very important to the pharmaceutical industry, because it's a big tool for them to settle their cases. Now, the landscape's been a lot different. You had this ciprofloxacin case that was a couple years ago where that payment was $400 million. Okay, that's a lot of money to settle a case to go back from the patentee to the accused infringer, whereas nowadays it's an order of magnitude less than that in a typical case. Usually tens of millions of dollars, maybe a supply contract, maybe something else. Maybe industry realized, said, hey, you know what, 400 million looks a little bit like a scarlet letter here on what we're doing here, so we'll take it back a notch, and that's why the agreements are much different today. But nonetheless, the FTC has been adamant about a per se rule that any reverse payment is per se illegal. Although, former Chairman Leibowitz of the FTC, I think, went on record yesterday and said he would be happy with a middle ground response from the court. Right? So no black and white line, as we were talking about. As Judge Lynn says, the Supreme Court's really not going to do a black and white line. More of a policy issue. We'll probably end up with something in the middle. So probably more on pay for delay than this audience wanted, but that's the background on the issue.
I think Judge Lynn also made a nice comment, is that our clients or our business clients, they need or want certainty, and actually certainty is extremely valuable to them, as probably that case dictates. But that's what I see in the Supreme Court. The second thing I'll follow up on what Jim said is that my CEO was astonished when I explained to him that an injunction wasn't automatic recently. So I think that's another issue. I'm also interested in the Myriad case with the green initiatives we have going on. We're always looking for alternative sources of natural rubber and doing a lot of genetic stuff with that.
Right. Yeah, no, it'll be very interesting, because that's the next wave of technology. Not, like you said, not just pharmaceuticals, but industry chemicals and rubbers and the polymers and so on and so forth as we go from there.
Yeah, because a lot of things are coming from natural products now instead of oil-based.
Right.
Although there's nothing wrong with oil-based.
No, there's not a thing wrong with oil-based. In fact, we use plenty of oil. Jim, you don't have to worry about that. Just keep the costs low, will you?
Just keep it at fair, John.
The guy for BP talking about using a lot of oil. That's funny. Okay. All right, Paul, any comment from you as we wrap up the Supreme Court segment?
I think probably the case that I'm most interested in is the Bowman versus Monsanto case. Mm-hmm. In our industry, there has been some patent exhaustion issues or interest. For instance, one example would be surrounding print heads. Print heads sold by an OEM as replacement print heads. Right. Mm-hmm. A lot of times they try to have a restrictive label license, say you can only use it with our authorized equipment. What happens if someone buys a bunch of heads and goes and makes their own equipment with them? So there are some interesting patent exhaustion issues that we something I've encountered.
And you get probably the repair doctrine too, then, if you're talking about ink cartridges and things like that, things that never happen in the pharma industry. That's right. Right?
That's right. So that case is probably of the current crop the one that may be most applicable.
Right. Anybody else encounter patent exhaustion issues in their practice?
I have.
You have, okay.
I have occasionally. We had a case where it was actually the non-practicing entity case, where they had granted licenses to some suppliers, and they had sued some of our suppliers of these genetic sequences. And sometimes we make them ourselves, sometimes we outsource them to third parties and purchase them. And they had licensed these third parties and provided a release for all past infringing acts. And then going forward, they limited the license to only research only, or in a non-commercial research only way. Unfortunately for them, we had purchased them in the past, so we were included in that. We claimed we were included in that release, and we prevailed at the district court and convinced the court that yes, in fact, the release did cover our use of those products, so the patent was exhausted.
That's interesting. So you get a lot of issues from exhaustion to the NPEs to the typical Hatch-Waxman cases. You've got to have a very dynamic in-house department, a very sophisticated department, right?
It is fun. So
let me ask you this question then, though. What have you seen the dynamic be between inside counsel and outside counsel in, let's say, your last 10 years of practice? Has that landscape changed, and if so, how?
You know, from my perspective, it's tough for me to say. When I was outside counsel, I had the fortunate or unfortunate, experience where I had actually very little interaction with our inside counsel. They didn't really seem to have much, day-to-day contact on the actual cases and didn't work as closely with us. Whereas our department, we, are constantly, our outside counsel would probably say we over meddle in the cases, and but my job is to develop the strategy for the case going forward and making sure my outside counsel implements the strategy we've come up with. And so from my perspective, since I've been at Abbott, now AbbVie, we do spend a lot of time on our cases and working very closely in the nitty-gritty deep details of the case. Whereas when I was outside counsel, I didn't have that same experience.
So let me clarify the myth then, right? Because I've been inside and outside counsel. Let me clarify the myth here. You know the minutiae of the case now. Are the hours in-house any better than the hours outside?
Yes, they are.
Yeah?
I would say they are.
How so?
Only I would say my day during the day is actually much busier than I ever was as outside counsel. I am, I constantly feel like a little bit like a ping pong ball, like I'm going from this to this to this to this, and all day long. Every hour I could be working on something different. Whereas when I was, but then when I work from 9 to 6:30. But then when I go home and I leave everything at the office. And I also say I have my weekends back. So I now no longer work on weekends. I work very, very hard when I'm in the office, but I work very little when I'm outside of the office. So that is very different from my experience being outside counsel, where I worked, pretty much the same all 24 hours a day, 7 days a week.
John, same questions to you. Has the landscape changed inside, outside, and the hours any better?
It's been so long since I've been outside counsel, I don't know if I can comment on that. I feel like that I work as much as outside counsel, except I'll agree with Karen, is that I protect my weekends for the most part. With respect to outside counsel, and I'd be interested in what the others say about this, is that it seems like in-house that things are so squeezed for cost right now. It seems that I'm very judicious about, very careful about how we're spending our money outside and trying to keep costs low in a lot of ways. And also it seems to me that in-house we're involved with a lot of the management of intellectual property, and so we engage outside counsel has become closer and closer to us. My budget hasn't decreased, it just seems like I'm doing more work.
Right? Do more with less, right? The mantra?
I feel sort of bad with beating up outside counsel. I shouldn't say beating up. I think it's a partnership, but I think there's a cost element now.
Right? Managing the P&L, you have to do that. Know your budget, right?
We do, yeah.
We got two more to go here. Paul, your comments?
Yeah, I think I would echo some of the other comments here that I think we're increasingly collaborative with our outside counsel. Regularly meet face-to-face. We're constantly looking at how we can more efficiently work together in terms of our kind of information workflows. Also to try to contain costs. On big litigation matters, I try to use internal resources, subject matter experts, to help with a lot of the discovery and the initial analysis and claim charting, all sorts of stuff. The more that I can bring in-house to do. But that's challenging too, because the business is very squeezed too.
But hasn't the legal services industry changed in that way? Because 10 years ago, the sophistication level has changed, right? At least from my perspective, on what you see on the inside versus the outside. Before, it used to be a lot more influenced by the outside counsel on the way the legal advice to the corporation. Where now the inside counsel is more sophisticated. There's more than one person there. Generally, now they have a team. They can vet ideas and steer the company in the right direction. So that sophistication is one change. The other change that I see would be in the way legal services are delivered, right? So you have no shortage of attorneys out there that can do this work, right, at any particular experience level. And what you see would be, and maybe you guys have engaged this, I don't know, but certainly in my practice would be, you've got outside counsel at a law firm doing one level of work, and they're actually engaging contract attorneys, right? So 10 years ago, who knew what a contract attorney was, right? But now they're reviewing documents and do all these other things that used to be the profit center for a law firm, and they've had to change their model and the way they're providing legal services and created this whole cottage industry now of contract services. So, with that foundation and the other questions I've asked the other panelists, Jim, I asked for your views on this issue as well.
I would say I've come from two in-house departments, BP and before that at 3M, very strong, large, well-regarded inside departments. So I always felt like the primary role of advising executives resided inside, and certainly the efforts you do are supplemented by close partnering with outside counsel. Been a lot said on costs and management now, or so I have nothing intelligent to add to that. Maybe something that's changed a bit over 10 years or so is I see a need more in very niche, deep expertise areas to rely on outside counsel until or unless you decide this is really going to be an ongoing issue and I want to build that competency in-house. So when BP acquired a biofuels company a couple of years ago, and overnight I had 125 researchers in San Diego doing biofuels, and we didn't have patent attorneys who knew that. Well, that's a deep subject matter expertise. I'm going to rely on outside counsel. If that's a sustained need, then we'll decide how and when to build that inside. Similarly, and going back to the biofuel, biodiversity is a real niche area of law, the thing that you don't even know what you don't know if you're not an expert. So there too, when we run into issues on that, let's get to the people who do this all the time outside, and then as we develop an ongoing need, we'll build that. So my balance with outside counsel has been, I think today, I find myself more often in some deep niche specialty where we're just not the deep experts. I'm going to rely on the deep experts and then decide when do I need to build that expertise inside and wean myself off of outside counsel if it's an ongoing need.
I don't think that's unlike the growth of any business and how they do that in any function of any organization, right? That's how they do that, I would say.
I also have one other thing to add. I think as far as changing roles of both inside and outside counsel, I think, not only has the role of inside counsel changed to become, a lot more strategic with, dealing with your executives and as well as your outside counsel, but we've required our outside counsel to change a lot too and make them more strategic instead of, you can't let your outside counsel just become focused on winning that case because they need to understand that winning that case may make you lose the war. Like there may be other cases with bigger implications that the tactics and the arguments that they're making in one case may be detrimental to a case that may be more valuable to the company. And we really require our outside counsel now to really consider that and make sure they understand not only their case that they're working on, but they need to understand the 6 other cases that are bigger than that case that are going on right now in the company or maybe coming down the pipeline for us.
Hey, Steve, Jim and Paul didn't answer how much they're working.
I work as much as I did outside.
Well, they won't be tracked for their billable time today for contributing to the panel discussion today, right? So,
and I find part of the challenge is with so many global companies, global constituents. We joke the sun never sets on my IP department. From Chicago, Houston, San Diego, London, Mumbai, Singapore. Somebody's always awake 24 hours a day, and it seems like I have to be communicating with them.
And that's the problem, or maybe not a problem. That's one of the effects of having a global organization, right? Because you said you had your weekends back, right? Well, when I was inside, the parent companies were in Switzerland and Germany, right? That's a whole other workday ahead, right? So I had my work, started my work on Sunday night.
But the travel, I mean, like Jim was saying, the travel in-house is tremendous. I don't know what it's like outside for the most part, or if you guys have that, but
right.
I made the mistake of counting. I traveled about 115 days last year, and I should have never confessed that to my wife, but I counted it up.
Well, I'll end that segment by saying, for those that are considering a move from outside to inside, the grass is not always greener on the other side. You have a wonderful panel here to ask them your questions in that regard. And with the balance of our time that we have today in a couple of minutes here, I would invite this group to take advantage of this extraordinary panel you have here and come up with some questions for them. So with that, I will turn it over to you for your questions. Shashank, thank you, sir.
many of the people here in the audience are obviously academics who actually study the law and then make proposals and scholarship as to what the law ought to be. Do the inside counsel ever look at that scholarship, use that in conjunction with their outside counsel to implement?
Right. Dave's hoping the answer is yes, absolutely.
If I could, I'll say two things in regard to that. I do find that helpful, particularly in an appellate setting when you want to reshape law a bit and you have a bit of a clear canvas to paint on. I think academic writing can help frame up your thinking and can help buttress what you want to say. I'd say it's also important in trying to shape public and media perception. Anybody here could point to all sorts of articles over the last couple of years what maybe begins to call into regard what I think is the fundamental underpinnings of intellectual property. You have to give innovators time to recoup their investment, and without that, it's a better business model to be the fast follower. And I think academic research can, I hope, revalidate the underpinnings that you need to give the innovators time to recoup their investment. I hope those articles that say that IP stifles innovation could be empirically or theoretically shown to perhaps be missing the mark in some regard. So I think there is absolutely a role.
So you're suggesting there should be a patent term extension or type period of that outside other industries like we see in pharmaceuticals?
No, not that nuts and bolts, but where people today see the cell phone wars and you get commentators, I think, shooting from the hip saying, oh, look at all of these patents are dragging down the system and it really stifles innovation. So just at a macro level, that I think that the shoot from the hip type commentary that's criticizing the IP world today, I don't think is really underpinned by some good research.
Okay.
I appreciate the question, actually, and I hope that the academics want to make a difference with the intellectual property owners, which I think you're looking at. We as a group, just this group, have a lot of intellectual property, and we talk about being able to capture the value of that intellectual property and use that in our businesses, hopefully to increase innovation. And this is one of the questions that we considered when we were looking at the panel, and I think Jim made a good point when he talked about some empirical evidence of actually how it's working and how things work from when there are changes made to see actually what's happening. I find it interesting, the debate back and forth of whether there should be, if the patent system, incents innovation or doesn't incent innovation. But I don't necessarily find it that useful. I find it interesting, but not that useful. Maybe it goes back to what Jim says, is that I think some of the academics or some of the press is picking up on some things that are written in that way. But if we could get closer to, if the legal academics could get closer to the economists or the business schools and do a couple things, is to write in that area how it's actually impacting business, number one. And number two, I posed this question to a couple other chief IP counsels or whatever our titles are of other large companies. And one of them actually mentioned that in addition to writing about that is to have some collaboration with the business departments and have some education, because I think that, and I would be interested in what the other panelists see in their businesses, is that the IP knowledge of our people graduating from business schools is low. And I think that we're constantly having to educate our people as to the intellectual property and how it's used in business. So I would like to see that. I also think that I read some of the academic articles sometimes, and I'm not sure that a lot of assumptions are made about how businesses actually make decisions, how things actually work inside a corporation. And I find them to be much different than what I see in my corporation, have seen in other corporations, and when I talk to other chief IP counsels as to which they see. And it kind of goes back to what Jim said, is that, they were marking these lubricants, and we had a case like that too. And of course, a big corporation like that would have a system in place that would be able to monitor these things. And you know, I would even make the argument that a small inventor may have an advantage on us on first to file. You know, so because you know, but that's my 2 cents. I appreciate your question, and I hope there can be some collaboration and some. I hope that academics do want to make a difference in that.
Yeah, I would just add, I think there are definitely opportunities for increased collaboration between academics and industry and IP owners. And particularly, I am particularly interested in the empirical-based studies, especially if you're to look at different proposals to fix some of the issues that have been discussed.
Any particular issues you want them to study, put on their short list here?
Well, I think my personal short list would be the high transaction costs of you know, identifying and disposing of, you know, less meritorious claims. And Dave and I have had some discussions on that.
Because I think it goes back to what Jim alluded to earlier, is that the inequities between the parties, and I think that's one thing the SHIELD Act may address. Right. But when you're looking at the inequities, you've got these, what I would refer to as ankle biters, these guys who come in and they say, give me $50,000 for this case, and you know, you serve the first discovery, and the resources alone internal are going to cost you more than $50,000, not including the outside, the transactional costs.
Well, that's
so the inequities.
Through litigation, right? Or go through litigation, right?
The
there was
efficiencies.
that NPE in Texas that just won, right? And validated the patent in the Eastern District of Texas. I don't know if that's ever happened, right? But it was an NPE case, and the other first 12 settled, and the other one said no, went through and invalidated the patent through a jury trial in Texas. You know, it almost came out on April Fool's Day. I was like, whoa, what? Is that real?
But it's interesting, and I'm not sure what the answer is, but I think that we can, a more efficient system would be very helpful to business.
Right. Any final questions we got? I thought we had another 1 or 2 questions. Yes, one in the back. Got time for one question for our coffee break?
With the majority of cases being filed now, the statistics show the majority are being filed by NPEs, and the majority of the largest jury verdicts have been going to NPEs, although maybe not holding up on appeal. Are you diverting your budget more and your focus more to high-quality work on the NPE cases?
You know, I think from my perspective, you know, not all NPEs are created equal. I think we look at them case by case. Sometimes you have these nuisance cases, I think you refer to as ankle biters. But then there are increasingly sophisticated NPEs there that have, you know, assembled some high-value patents in some cases. And so I think your strategy will be shaped accordingly. You know, look at what kind of counsel is representing the NPE. Are they experienced patent trial attorneys? Something to take into account. What's their track record? So I think we've increasingly adapted a pretty nuanced approach to looking at you know, cases filed against us, really, and even in the NPE context, and I think increasingly so in the NPE context, looking at and you know, adapting to the specifics of that case.
I think that Paul makes a good point. Is that, and he's looking at the merits of the case, and so I think your focus on NPEs is misfocused. I think your focus should be on, is it valid and enforceable? And I think that I think there is litigation abuse, but all NPEs are not created equally, and I think it has to do more with the patent that's at that issue. And yeah, I would imagine that the person who settled the case that got a large jury verdict, or if it's held up, was probably a good patent.
Well, any damage award is going to be subject to scrutiny, right? Apple, Google, you know, the billion-dollar judgment coming down. I think J&J just had a $600 million judgment, jury verdict, you know, award vacated. Right, so yeah, that's the next wave of litigation on the damages phase, right? So,
you know, I think Jim at least was. We attended the conference, and Judge Rader gave an excellent speech on the problem is not NPEs. It's a litigation problem. It's whether the patent is valid and enforceable, and I think that's what. That's what my focus would be on.
I think the game is evolving, though. As you recognize, if I were to have to clear a product 10 or 15 years ago, you could do some search on your competitors, you do some search on the technology, you take a reasonable look and you think you're reasonably confident. I think with this very sophisticated industry that's emerged, you really run the risk of missing the needle in the haystack. It's not going to be a competitor. It's maybe something that doesn't show up on your first pass. It's something that you may not know is there, and you do a significant reliance on feeling safe on some clearance. And I think the game is changing. I think you have to decide what are the efforts of clearance you go into. I think we have to look at these industries that are evolving. Do you buy into these kind of patent licensing pools where, okay, I'll join the club. You go buy thousands of patents, I'll join the club. I think it's evolving. We're not on the cutting edge of that, but I think it's going to require some close analysis on what's the right way to protect yourself, because you're right, litigation's litigation, but it's a very different class of plaintiff these days that's driving all the litigation.
Great. Thank you, Jim. And let me thank my Fab Four panel up here, Jim, Karen, John, and Paul. Really thank you for your time today. I want to give you a round of applause. Really appreciate that.